for those that are actually over in the eastern states anyway. For those in the over in WA, it's probably a little bit earlier, I would have thought, but thanks anyway for joining us today. Today I'm going to talk to you about liquidations and how a liquidation, in the most part works, what happens when a liquidator gets appointed, what the obligations of a liquidator are, and the sorts of things that happen within a liquidation context. So I'll share my screen. And by the way, liquidations are probably the most common form of insolvency that we get involved with. We've discussed voluntary administrations. They can lead to a liquidation. We've discussed bankruptcies, which are personal. So at the end of the day, liquidations still are the most common form of insolvency that we get involved with. The government has introduced, as Chris said, some new legislation, which, assuming it passes through Parliament over the next few weeks, which I suspect that it will, from the 1st of January, there will be a simplified liquidation process, and but together with a restructuring plan process that sort of takes the place a little bit of a voluntary administration, to a much simpler form. And what the government's trying to do there is the government's trying to simplify the insolvency regime, I suppose, that's set out in the Corporations Act, so that a lot of businesses can avail themselves of it, and it's a cheaper process, simpler process, with a view that the insolvency restrictions that the government had put in place will be lifted come the end of the year. So I'll share my screen with you, and hopefully this works, because we have had some problems with this over the last short period of time. So Chris, can you let me know if you see that?
No problem at all, Steve. It's operating.
Oh, fantastic. Oh, that's music to my ears. All right, so assume you can still see it.
Yes.
Excellent. Okay, so that's good. We can get started. Okay. So there's a number of ways that, firstly, a liquidator can be appointed. So the very first way a liquidator can be appointed, and the most common way a liquidator can be appointed, is by the directors. So what happens is that there's a directors meeting that's held, and at that directors meeting there is a resolution passed that the company can't pay its debts, or may not be able to pay its debts as and when they fall due, and that the company should be placed into liquidation, and that a shareholders meeting should be called in order to pass a resolution to put the company into liquidation. So assuming that that resolution is passed at a directors meeting, the directors then call a shareholders meeting, and at that shareholders meeting a resolution is passed to place the company into liquidation, and the liquidator, the person that's consented to act, so a registered liquidator, becomes the liquidator at that particular meeting. Now, this can all happen quite rapidly. What generally happens is there's a meeting of directors, and virtually straight after the meeting of directors, there's a meeting of shareholders. And the reason that that can happen is that normally the director is also the shareholder, and they can consent to what we call short notice. And what that means is that basically, in order to call a shareholders meeting, you normally got to provide 21 days notice of the actual meeting itself. And it is an extraordinary meeting of shareholders or members. And what shareholders can do, though, is they can dispense with that 21 days if they all agree, and hold the meeting closer in, and generally straight after the directors meeting. So it happens pretty quickly. Another way that a liquidator can be appointed is through the courts. So what happens in those circumstances is where a creditor is owed, and at the moment it's $20,000. They can apply to the court to have the company wound up. And so one of the creditors that does this the most is generally the ATO. So before the COVID insolvency restrictions came in, what a creditor had to do was issue what we call a statutory demand, and that would generally go to the company's registered office. And from there, the company had 21 days to comply with the statutory demand, to apply to have the statutory demand set aside, or the creditor could then take that company to court and have the company wound up if the court was so minded to do so. And the amount that had to be owed was only $2,000. So as at sort of the end of March, that amount increased to $20,000 temporarily, and rather than waiting 21 days, a creditor had to wait 6 months to do it. So those restrictions come to an end on the 31st of December this year. We don't quite know at this stage whether it's going to go back to $2,000 in 21 days. It may very well go back to a higher figure, maybe somewhere between 2 and 20. It might stay at 20. We don't really know just yet. And the period of time might change. It might change from currently it's 6 months, but it might come back to maybe 45 days. But we'll just need to watch this space because we just don't know. The government hasn't released any information about that at the moment. The other way that a company can be placed into liquidation is it could go through a voluntary administration. And at the end of the day, if there's no proposal for a deed of company arrangement, generally the company will go into liquidation. Or alternatively, there might be a deed of company arrangement proposed, but creditors might not agree with it, and they might want the company to be liquidated. And with the liquidation, some investigations done into the company's affairs, and maybe some recovery action that's actually required to be taken. So the very first thing that we do when we get approached to do a liquidation is that we do a conflict check. And the insolvency industry, the laws are very strict about conflicts, so we can't have had any involvement with the company apart from maybe providing some pre-liquidation type advice. So maybe the directors have contacted us or the accountants contacted us, and we've spoken about the company's financial problems and the options that are available to the company. And one of those options might be liquidation. That's fine. But if we're, for example, being the auditors of the company, then we can't obviously take that particular appointment. And once we've cleared that there is no conflict, we provide what we call a consent to act. And this is in relation to any type of liquidation that we do. So we consent to act, and that's basically saying that if a resolution is passed or the court makes an order to wind the company up, we consent to act as the liquidator of that particular company. So once we get appointed, basically the process of all the liquidations, whether it doesn't matter which way you've been appointed, they're all the same. So these are the sorts of things that we do. So we'll get a company search. So the company search gives us a whole heap of information. We'll get an historical company search from ASIC. It tells us who the directors are, who the directors were, who the shareholders are. It will tell us maybe what the PPSR registrations over a company are and who holds those. So who are the secured creditors, so we can contact them and find out what security they've got over particular assets that the company might hold. If it's a court winding up, so where the court's applied to wind the company up, the court's made the order to wind the company up through a creditor being owed money, we'll contact the solicitor that was acting for that creditor to find out information. We'll also maybe contact that creditor as well, because creditors generally are the people that have the most information about a company. And with court liquidations in particular, we know nothing about the company when we get appointed to it. It's a bit like it's a lucky dip as to what you might end up getting. So I've been appointed to companies maybe from the ATO, which have ceased trading maybe 4 or 5 years ago, and there's absolutely nothing left, and the trail's gone cold. And I've been appointed to companies that are still trading. I ring the phone number up. The ATO or their solicitor tells me that I've been appointed the liquidator of a particular company, I'll ring them up and they're still trading, which means that we've got to go out and then take control of the actual business itself. So it's very important for us to determine the trading status. If it's a voluntary appointment, so one done by the director and the shareholders, we generally will know what all that information is prior to being appointed, because we will have had those discussions. But as I said, there are really sort of two parts of being appointed. One where it's voluntary, done by the directors and the shareholders, and one where it's done by a creditor. Generally, we'll look for bank accounts because, and we send out a circular to the banks asking them to freeze any bank accounts, particularly for withdrawals that might be going out of the bank account, direct debits that might go out. But we normally leave it open, at least in the short term, for any deposits that might come back in. We also tell the directors about their obligations as directors to cooperate with the liquidator. One of the interesting parts of a liquidation when we get involved in it is there are different types of insurance that we can get. And as an insolvency practitioner, there's now three insurers or insurance brokers that deal with insolvency insurance. Now you might say, well, what's insolvency insurance? Well, what it is that when we get appointed, a lot of cases, insurance policies that a company might have a clause in it that says if the company is insolvent, then the policy no longer responds to any particular incident. So when we get appointed, we might not know, as I said, anything about the company, but we will send a notification through within 7 days to say that we've been appointed over a company, and we get what we call automatic coverage. And what automatic coverage does is that it covers most risks and situations for us, and until we can get on top of what the insurable risks in an organisation might be. There's a couple of exceptions to that. We would need to refer, say, a nuclear power plant to the insurer to see whether or not we can get specialised insurance. And sometimes, because the risk that we're trying to get covered by insurance, the business might be so unusual or of a fairly risky nature that our broker will need to go to the current insurer and say, look, we want to keep the current insurance in place, but you need to understand that this company is in liquidation and there are risks. Now, why, you might ask, do insurance policies maybe lapse if a company goes into liquidation? Well, that's because there is a whole heap of risk that is associated with a liquidation that might not necessarily be associated with a business that's trading profitably. So to give you an example of that, it might be, for example, we had a situation recently where we had a number of, it was a unit development. So the unit development, there were 3 townhouses that were built, and I got appointed over it. And what we ended up finding was that 2 of the houses in this block were being used as drug dens, and there was, it's very interesting when you get appointed to something that's been used as a drug den, because there are companies that go out and actually cleanse these places out. They're specialised sort of cleaning services and what have you. Now, when we had a drug den, of course, the place tends to be trashed in many respects, and it certainly was in these particular cases. And there's a claim in relation to insurance on that. When a company goes into liquidation, people also do some funny things. Including they think that they can take some of the company's property, and because they might be owed money, and possession's 9/10 of the law. It doesn't quite work that way, but certainly there are certainly people that are out there over the years that I've come across that all of a sudden think that the property that belongs to the company in their possession is now their property because they're owed money, and it happens quite a bit when we get appointed to transport companies. Sometimes some of the trailers and the trucks tend to go missing for a while. We report them stolen to the police, and eventually they turn up. So we do that. We have to advise ASIC that we've been appointed. So if you ever want to know about a company that you think might have gone into liquidation, you can do a search on the ASIC notices website, and that will tell you, or should tell you, whether the company has gone into liquidation or not. So you can do that search. It's free. You can see probably the notice that's been lodged by the liquidator to say that that particular entity has gone into liquidation. We notify the ATO and what happens there. So if you've got a company that has gone, one of your clients has gone into liquidation, you might be aware that there are different CAC numbers when you go into the ATO portal. So what happens is that the ATO will create a new CAC number for the liquidator, so that any, say, realisations of assets that we might sell that might have GST as part of it, any expenses that we incur where we have to pay GST, we lodge BAS statements just like the company does, but we lodge it through a different CAC. So when you see maybe you've got a company that has gone into liquidation through one of your clients, if you can get access to the portal, and you probably won't be able to, but generally speaking, there'll be the company's old CAC, which is all the old debt that might be owed to the tax office, and then you might see a new CAC, which is the liquidator's lodgements. We notify work care or work cover. We also notify the State Revenue Office. Work cover is really important because if we're still trading a business on, we need to make sure that there's a policy in place, and different states have different requirements in relation to work cover. So, sometimes I think in Victoria they'll allow the policy that's in existence to continue on. In some other states, perhaps I think Queensland, I think from memory, you have to actually get a new work cover policy if you're a liquidator. We'll contact the directors, we'll send them a written notification telling them what their obligations are. Now, a director still has ongoing obligations as a director when the company's gone into liquidation. Some of those obligations, for example, are simply to cooperate with the liquidator, to provide the liquidator with any books and records of the company or any property that the liquidator might not have in the liquidator's possession. So it might be somebody else, to cooperate and tell the liquidator where that is, to complete what we call a ROCAP, which is like a financial statement of the company at the date of liquidation, and provides information about the company's affairs. Fairly easy to fill in, but it basically will list down the assets and liabilities of the company and will assist the liquidator in trying to make sure that all assets are collected. So simplistically, what does a liquidator do? Well, a liquidator collects all the assets, brings them all in, realises them, funds go into a central pool, and then distributes those funds out in accordance with the Corporations Act. The other job the liquidator does is investigate the company's affairs, because sometimes money might have gone to places that it shouldn't, may take some recovery action in relation to that, but also reports to ASIC as to why the company is in the position that it's in. So why has it gone into liquidation, and whether, in the liquidator's opinion, the the directors have committed any offences, and then ASIC will then determine whether or not to investigate any of those offences that might have been reported. Now, generally speaking, in a fairly small liquidation, or the sort of SME type liquidations that we do, we'll report to ASIC, and probably 9.9 times out of 10, they will send something back to us literally within a minute or 2 minutes, saying that they're not going to investigate that company's affairs. Now, where that changes is where there might have been a significant amount of money lost, generally by, say, mum and dad consumers or investors, or it's a big liquidation and there's concern about the fact that money's probably gone missing, or there's been serious offences that have been committed, in which case the liquidator will be involved with ASIC in relation to those particular matters. Some of the other things that happen is that if a person is a director of more than two or more companies that have gone into liquidation in a period of 7 years, and where the liquidator has paid less than 50 cents in the dollar, then there's an application that can be made through ASIC where another report's done, if ASIC requires it, and that's used for the purposes of considering whether the director should be banned from being a director of a company for a period of time. And you'll see those directors that are banned. If you go onto the ASIC website, you can actually see the names of those directors that have had a show cause notice as to why they should be a director. As I said, we do all sorts of searches. So Liquidator's got a fair amount of power in terms of doing searches on behalf of the company. We'll search the road registries to see if there's any vehicles that have been registered, any boats that might be registered. We'll do a land title search. We'll circularise the major banks to see if there's any accounts. And we'll do a directorship and shareholder search on the directors and shareholders to see what other companies that they might have been involved with, just so that we can get a picture if we come across those companies when we're looking through and examining and investigating the company's books and records. So as I said, one of the major things the liquidator does is to realise assets. So one of the very first things we do is we secure the assets. So it might be a trading premises, we go in, we'll change the locks, or we'll make an assessment as to whether or not the locks should be changed. Now, sometimes we don't change the locks because we've got confidence that the assets are secure, and it might be that, for example, that the business operates 24/7. So in those particular cases, obviously we can't change the locks, and we're not going to be there 24 hours a day, 7 days a week to operate that particular business. We'll put controls in place, but we won't be there on site all the time. We'll collect the books and records of the company. So a lot of the records these days are kept on MyOb or Xero, and we'll try and get access to those records. We'll write to MyOb and we'll write to Xero. We'll get them to make sure that we actually have access to them, and that only we have access to them, because the records are really important, because we don't want those records changed. We don't want the records to be altered in any particular way, and it's important that we lock those down to make sure that they're available for our investigations. We'll go and get a valuation of the assets done, and part of the reason that we do that is we want to know what they're actually worth, and there might be a variety of reasons. So for example, it might be that there's a lease company that's got a car, and the company has leased the vehicle. We'll get a valuer to give us a value of the vehicle, and assuming that the lease company's security is valid, if the vehicle doesn't have any equity in it, in other words, the payout figure is worth more than or is higher than what the value of that particular asset is, we'll disclaim that asset. And so what that means is we'll send a notice of disclaimer to the finance company saying we don't have any interest in this particular asset. You're free to go and deal with it as you see fit. We'll also advise the guarantors of that particular finance contract that we've disclaimed it. So what that means is that we can, once we disclaim it, a guarantor, which is generally the director of the company, is free to actually go and start negotiating with the finance company in relation to that particular asset. So what that means is that, let's say you've got a motor vehicle, let's say the payout figure on the motor vehicle is 50,000, but the vehicle's only worth 30,000. So we'll disclaim it. The director may very well turn around and say, well, look, I want to keep the vehicle because I know that if the finance company comes and collects the vehicle, what will end up happening is that they'll go and sell it down at the auction rooms. They'll get a small value for it, and then they'll come and chase me as the guarantor for it. So I may as well keep it. assuming that I can make the lease payments on it. And generally speaking, finance companies are fine with that. They're fine with it because they know that potentially if they go and collect it, they have to go and sell it at auction. They're not going to get a great value for it, and they may as well get the value by trying to have the lease being paid for by the director over a period of time. They'll get much better value for it than that. We'll look at the financial statements. We'll look at depreciation schedules in particular. And the question that we ask with depreciation schedules is, okay, well, these assets are shown on the depreciation schedule. They're not here anymore. Where are they? And that's where the director comes in relation to assisting us with our inquiries to make sure that all the assets of the business are actually collected. Give you an example. I'm working on a matter at the moment. I was appointed by the court over a company in New South Wales, and we got some. In fact, we got some records from the solicitor that acted for the creditor that wound the company up, and we got some correspondence. And basically, the correspondence says this company has no assets. Go and wind it up because you'll get nothing. So anyway, the creditor did go and wind it up, and I got appointed by the court as the liquidator. And so I ended up getting some financial statements in particular and some tax returns because, again, a liquidator can approach the tax office, and we do effectively what is like a freedom of information application to the ATO to provide us with all the tax records of that company before it's gone into liquidation. So what we see is firstly the debt that might be due to the tax office, any payments, we'll see their running balance, but we also see all the notes that the dealings with the company, maybe the tax agent has had with the tax office, because they're all written down in notes. So every time you contact the tax office, as you probably know, they take pretty detailed notes of the discussion. We also get to see what was disclosed in the tax returns that were lodged as well. So we grabbed the returns in this particular case, we grabbed the depreciation schedule, and we said, well, where are all these assets? And then what we then found out was the assets supposedly had been sold. We get a copy of the sale agreement, and the sale agreement's got all these different clauses in it, one of which is that the secured creditors, the banks or the financiers, had to agree with the sale. So we approached the financiers and we said, well, are you aware of the sale? And they said, no, we're not aware of the sale at all. We haven't found out, this is the first time we've heard of it. So, of course, we then go back to the director and say, where's all this equipment? And then, lo and behold, what we find out is that it's been carted off site. It's down with somebody else who supposedly are using it. And then, of course, we have the fun of trying to then try and recover that equipment on behalf of the creditors. So we're still dealing with it at the moment. We've gone from a situation where the company had no assets to the company's got some pretty valuable pieces of machinery that are sitting with this supposed purchaser, which we're currently negotiating a purchase price with. Again, we're getting a valuation of those assets done to make sure that we're getting proper value for those particular assets. Retention of title and PPSR claims is another big one that we come across. So what happens in a liquidation? Everybody scrambles to try to get the best position that they possibly can once a company has gone into liquidation. So you've got to deal with the landlord, you've got to deal with potentially unions, employees, and then you've got creditors. Okay, so it might be a simple trade creditor. So trade creditor might have provided some widgets. They always seem to be heavily in demand widgets. And what happens is if they've got good terms of trade, and so the lesson here is how do you deal with a liquidator for your clients, and what to look for and what questions to ask your clients about when they're actually dealing with their client before they've gone into liquidation. So good terms of trade, coupled with the ability to lodge a security interest on the PPSR, is great. That means that then once the company has gone into liquidation, they can turn around and say, Mr. Liquidator, We want to know how much of our stock is still sitting on the floor of the business that you've gone and is in liquidation. And if their claim is a valid claim, the liquidator has to account to that particular creditor for the use of any of that stock, or the creditor can go and collect the stock that they might be and apply that against any debt that they're owed. So it's really important if you're talking to your clients about the best way of securing up any of the debts that they might be owed. First rule is to make sure that the terms of trade are up to date and allow for registration on the PPSR. And secondly, that they actually do a registration on the PPSR. It's cheap. It's really cheap. You know, I think it might be like $6 or $12 or something like that to get a registration on the PPSR. But you've got to make sure it's done correctly. And if you want to know a bit more about the PPSR, we did a webinar a couple of weeks ago on the PPSR. Just contact Chris. Happy to send you a copy of that. You can share that with your clients. A really important issue. Ultimately, at the end of the day, if we have to shut a business down, we might send the goods to auction. We might advertise the business for sale as a going concern. There's all sorts of ways that we might be able to sell a business. And if we can't sell the business as a going concern, because that's generally where we're going to get the best value for us. So going concern, basically, we're selling a business that someone can walk into and start operating effectively. If we can't sell it like that, what we end up doing is we generally send the goods to auction. And again, we've got to assess what the best way of actually selling particular items are. So if we're selling on site, so at the company's premises, we generally get the landlord's permission, because landlord's going to want to know, firstly, that the premises are going to be looked after and that they're going to be cleaned up once we've gone out there. Now, some of the sites that we go onto, they've been in operation for maybe 20, 30, 40 years, and there's 20 or 30 or 40 years of accumulated rubbish that are at some of these premises. So the landlord wants to get them out as quickly as possible so that they can get a new tenant in and rent their premises out again. So one of the things the landlord wants to make sure is that the premises are going to be left in a tidy and neat condition, so that it enables them to lease it out as quickly as possible. Other times it might be that we just take the stuff off site. So it might be, for example, that there might be a couple of vehicles. You don't auction them on site. They just go down to the auction rooms and they're sold that way. I did have a situation a couple of years ago where I got appointed again by the courts, and it was over a lady's specialised handbag business. So business made handbags for ladies, very specialised ones, and it also sold them through a retail outlet and sold them to some of the major department stores. And we looked at it, and we had in storage, ultimately, there was a bit of a backstory to it, but we ended up getting about 6 pallets worth of designer ladies' handbags. And I remember talking to the auctioneer about it, and the auctioneers had valued these handbags at about, say, $17,000 odd. And I said, well, how's that? I mean, they retail for hundreds of dollars each. And I said, well, we're just going to sell them. We'll just sell it. We'll just sell each pallet of handbags. And I said, well, I'm not in a real hurry to actually go and sell the stuff. Why don't we sell them online through to the general public through one of these online sales? So we actually used Grays Online to do it. So we unpackaged all the pallets of handbags, and what we did was we sold, probably 20 or 30 bags a week. And then when it came to Mother's Day, we had an extra special sale, big Mother's Day sale. Anyway, we ended up clearing out of that auction 170 grand. And so it just goes to show the different ways that you can realise assets as a liquidator. as I said, we get appointed from time to time where the business is still trading, and I'm just going to quickly run through the sorts of things that we do. So when a liquidator is appointed, a liquidator takes control of the business. So liquidator is ultimately in charge for everything that actually happens. So one of the very first things that we do is we need to make sure that the premises are safe. So I got appointed to a mining engineering company. So it was a company that repaired and made tools for things like those mole machines, you know, the ones that are digging out tunnels, those that for maybe the railways, maybe a tunnel under the Sydney Harbour. It might be those big mole machines that have the big blades that go around and actually dig through, dig underground effectively. And so I've been appointed to that, and there was this thing that was it was like a circle, I suppose, and it was probably about 4 stories high. And anyway, I just got appointed to it. I've gone out there. One of the very first things we do is we get an OH&S assessor out to make sure the premises and the work that's being done on site are safe. And the OH assessor came out the morning I'd been appointed, and they looked straight at this particular item that was being repaired, and they said work on that has got to stop immediately. And the reason the work on that particular item had to be stopped immediately was because you had these people that were up ladders doing work on this piece of machinery. And anyway, so what ended up happening was we ended up having to build scaffolding around this particular thing. So scaffolding went pretty high, and then once we had the scaffolding and it was deemed to be safe, then the work could continue to commence on that. It's really important that that work sites are in fact safe, because a liquidator, just like a director, if we operate a site that's unsafe and somebody gets injured or dies, the liquidator can be criminally charged for for actually allowing that work site to continue. So it's really important that we make sure that the sites are actually safe for the workers, as any of your clients should do as well. So there's also things like EPA issues. Now, I've been appointed over the years. I've been appointed to one recently, actually, where it was a tyre. This business collected tyres, and it had a block of land, or a couple of big blocks of land, and what it would do was go around to all the tyre recyclers, and it would collect all the tyres. The tyre places would pay maybe $5 a tyre to have their tyres collected. And what would happen is this company would go and they'd dump it on their land, okay? And so there was like 1 million tyres on these blocks of land that were there, and you might have seen some of this on the news. Anyway, what happens with tyres on land is they can become a serious fire hazard. And if they catch on fire, they are very hard to put out. And of course, the smoke that's actually released from these tyres is toxic. Okay, so in this particular case, the EPA had actually gone in and had cleaned up the site, because the directors wouldn't do it. They actually went and cleaned up the site, and it cost $1 million to actually clean it up, which they then claimed off the company, and ultimately the company went into liquidation, and the land's in the process of being sold. The land is now totally clean. But sometimes we also get appointed to sites where the land is contaminated. I remember going out really early in my career to a site where you walk out there and there's all these old rusty galvanised sheds. There was no, there was muddy water and driveways and things like that. Just a horrible place to be. And going into one of these sheds and seeing 44-gallon drums that were rusted and stuff leaking, and it was like, oh, you want to get out of here as quickly as you possibly can. But a liquidator gets involved in that. Now, in those cases, we may very well disclaim that particular asset because the costs of rectifying it actually are worth more than what the asset, being the land, might be worth. We'll talk to the staff about continuing to trade a business on. We'll do some assessments to make sure that we can do that. We'll do cash flows. We'll put controls in place. The best people to run a business when we get involved and the business is still operating are the staff and the management of the business. They know how to run the business. It might just be that they need some controls put in place and some expertise in how to run that particular business. But the people that can run a business the best are the people that are in the business. So generally speaking, when we get appointed to a job, we don't send an army of people out to go and run a business. Generally speaking, we only have 3 people on a job: myself, a manager on the job, and a staff member. We put controls in place, and once we're comfortable that those controls are in place, and they might be, for example, purchase orders, a purchase order system, because I'm responsible for any purchases that might go through. That OH&S stuff that I'm talking about, we'll set new bank accounts up. But once we are satisfied that the assets aren't going to be dissipated, then we'll allow the business to continue to trade on, and we'll look to try and find a buyer for that business. Because as I said before, generally the most value that you get out of a business is where you sell it as a going concern. As I said, directors have got to cooperate with us, and as I said, they've got to complete a ROCAP, provide books and records, and provide assistance where required to the liquidator. Their powers cease, however. They can't control a business anymore. They can't instruct staff on what to do unless the liquidator approves the director actually doing that. But look, a lot of the time, we'll work with the director. So, recently I had a cabinetry manufacturing business, and the directors decided to close it down, put into liquidation, owe the taxman a fair bit of money. And but one of the things that we looked at was the work in progress that was there for the business, and trying to make sure that work in progress was finished, because that maximises the sale on the assets of the company. So we knew the directors, we had controls in place. The directors actually supervised all that work to make sure that it got out. The reason they did that was because they know the business back to front. They know the customers. They were best placed in terms of doing that. I couldn't. I'm not very good at cabinetry, and if I was trying to install some kitchen cupboards, unfortunately, I suspect that most of the doors would be fairly crooked, I suspect, but the directors certainly knew how to do that sort of thing, and how to instruct the staff to make sure the job was done properly. Sometimes directors... Yes?
They've got a question from Yeva.
Yes.
It's a common event where the companies go into liquidation merely for the purpose not to pay their creditors.
Companies go into liquidation because they can't pay their creditors, generally, because not that they... Look, I don't know, a lot of the directors that we talk to, they don't ever mean to go into liquidation, but, the commercial reality is that sometimes, the business just isn't trading profitably. If you look at the circumstances at the moment, you look at travel agents. That's probably a really good example, I think. Travel agents, they've got, I think I saw something on the news last night, and it's really true. If they were a supermarket, they'd have nothing on the shelves, right? Unless they're doing some form of domestic travel, and even that's pretty difficult at the moment. Travel agents generally don't have anything to sell, so their sales are, plummeted. They may very well owe their landlords money. They may not have enough money to actually pay some of their clients back for some of the travel that might have been booked. And so they don't mean to go into liquidation, but they might have no alternative other than to go into liquidation. And so a lot of the time, we'll sit down with a director, and the director will say, well, I want to pay all these people back. And look, and I've heard that so many times over the years, and I think it's a very noble gesture. But when a company goes in liquidation, generally speaking, they don't need to pay their creditors back. But if they've got enough money somewhere down the track and they want to, nothing stops them from doing it. But the thing about being in business is the commercial reality is that from time to time, businesses are going to fail, and that's why there are insolvency laws in place. So, I think that people shouldn't feel bad about having a company that fails. And in a lot of cases, they've tried their best, and it might be just particular circumstances. As I said, like travel agents at the moment, they could never have predicted what would have happened this year. And some of those travel agents have been in business for 20 or 30 years. So yeah, most reasons why a company goes into liquidation is it can't pay its debts, and the director wants to deal with it, probably because they're getting harassed by creditors chasing money, and they know that they just can't pay. Just moving, hopefully that answers the question for you, but if it doesn't, just speak out, and happy to try and elaborate a bit more if you like. But a very good question. In relation to sometimes directors, and it happens more often where we get appointed by the courts. So that example, for example, of the business that had the plant and equipment that's moved off to some other premises. Phoenix activity, that's where basically a business has sprung up, which is the same business, maybe using the same equipment, with the same employees, maybe even using the same name or a very similar name, has sprung up, but the debts have been left behind in an old entity. Those sorts of things happen a bit, particularly in the court type jobs that we actually get. And if we don't get the cooperation from the director, one of the things that a liquidator can do is to publicly examine the directors and others that have been involved with the company. And what that entails is we put an affidavit into the court, and we say we want to examine particular directors in relation to the affairs of the company. And the court then, if the court's agrees with the liquidator that it's a matter that should be examined in court, then summonses are issued on the individuals. Normally what happens is they've got to deliver books and records and documents first, and then a couple of weeks later they attend court, get in the witness box and be examined by a barrister in front of a judge. And so that's what happens. They're pretty serious. I had a case a number of years ago where I was conducting examinations, and we turned up to the court, and the books and records had been delivered, but we turned up to the court on the day that the examinations of the directors were meant to take place, and the directors weren't there. And we'd received an email just prior to the time of the court being held, and it said that one director was in Melbourne. One director was on his way on an aircraft to Perth, and the other one was on his way to Brisbane and wouldn't be attending that day. Well, I can tell you the judge had a field day. He was ropeable, right, because he had presided a couple of weeks before when the individuals had to turn up to court, and he had specifically said to the directors, now you will attend court on this day. Anyway, our barrister was asked what he wants to do. And if you don't turn up to court and you've got a summons to turn up, then what happens is that the judge could make an order for you to be arrested. And that's what ended up, the judge said to the barrister, I'm going to issue an arrest warrant after lunch. Can you please contact the person that has sent the email and advise them that if the directors aren't here after lunch, then that's what's going to happen. And so we did. And at 2:15, when the court was, when the court came back into session, lo and behold, the directors were there. They were the director they were able to turn the planes around and come back from Perth and Brisbane and land at Tullamarine and actually get to the court really, really quickly. So, which probably meant that they probably weren't on the planes in the first place. And anyway, as I said, the judge wasn't happy. The judge got them into the courtroom together, sat them down, in fact, made them stand in front of the judge, and he said, this is the Supreme Court of Victoria. What was going to happen was I was going to issue an arrest warrant, and I would have made sure that, and you would have been arrested, thrown into the cells, and then I would have had to hear an application for you to be released. my time is pretty taken up at the moment. It may have taken some time for you to be released. At the end of the day, he got them back in again because the matter was over a couple of days, and he said, "So what time are you going to get here tomorrow?" And I think both directors said, "Well, 10 o'clock when the court opens." The judge turned around and said, "No, you'll be here at 9:30 because I don't want you to be late." So he wasn't happy at all. But that's how serious an examination is. So just quickly, because I know we're running short of time, we've realised all these assets, and physical assets are generally fairly straightforward to realise. As I said, you either auction them, sell them as a going concern, but there are other recoveries that we can make, and some of these recoveries you might come across. So one of the recoveries we make, unfair preferences. So payments made within 6 months of the company going into liquidation, or what we call the relation back date, which might be when the application was filed to wind the company up. They can be recovered by a liquidator, and the whole purpose of that is to try and put money back into a central pool and distribute it evenly amongst the creditors. So generally with a preference, and they're the most common ones that your clients might come across, a letter from a liquidator claiming a preference. We issue preference claims against the ATO quite a lot, okay? And generally it's payments that are made within that 6-month period where the creditor should have suspected that the company was insolvent or would become insolvent at the time the payment was made. And there's a whole heap of reasons why that might be. The most particular one being that they've taken some form of legal action to try and recover the debt. So unfortunately, it penalises those creditors that really take a positive step to try and recover the money that's owing to them. If they subsequently get paid, they might have, for example, have issued an application to wind the company up, and let's say that application was for, say, 20 grand. They get paid on the steps of the court, the 20 grand, and the application gets dismissed. But then in 2 months' time, somebody else goes and winds the company up. It's pretty straightforward for a liquidator then to try and recover that $20,000 off that particular creditor. So they're quite common. Uncommercial transactions, I'll group those together with unreasonable director-related transactions. They're claims where, for example, it might be that the company's business has been phoenixed. Okay, so it's been moved off into, all the assets have been moved off into another company. In a lot of cases, what happens is that it might be called XYZ Proprietary Limited. That's a company that's gone into liquidation, and then it goes off into XYZ and in brackets Australia Proprietary Limited. So, the name is roughly the same. The employers have been moved across, the assets have been moved across, and all the debts stay within the old entity, and there's been no consideration paid for the assets themselves. That's an uncommercial transaction, but it can also be an unreasonable director-related transaction. The difference between the two is an unreasonable director-related transaction obviously involves a director or a close associate of the director, and this sort of provision was brought in for OneTel and Jody Rich. And you may recall, it was a fair few years ago, but bonuses were paid out of OneTel, and they were $1 million bonuses, and Liquidator had trouble recovering those bonuses, and so ultimately they brought this unreasonable director-related transaction provision in to enable Liquidator to actually recover transactions like that. Now, the company doesn't need to be insolvent when the transaction occurs. You can certainly go back a fair period of time to try and recover these types of transactions, uncommercial transactions and the like. You can go back 4 to 5 years to try and make those sorts of recoveries. There's a whole heap of things that you've got to go through, but they are certainly other recoveries that are available to a liquidator. The other one that is quite common is insolvent trading. So insolvent trading, at the moment, there's a moratorium effectively on insolvent trading up until the end of the year, and a moratorium in relation to debts incurred by a company in the ordinary course of business. So if it's not in the ordinary course of business, then it's not covered. Okay, but if it is incurred in the ordinary course of business, and that might be, for example, a debt that's due to maybe a landlord or a debt that's due to a supplier, for just normal business, then the director, if the company goes into liquidation, won't be caught for that particular debt for insolvent trading. So what happens in insolvent trading is the liquidator will deem a company to be insolvent at a particular point of time, and then will make a claim on the director for any debts that were incurred that haven't been paid from the date of that deemed insolvency day right through to the date of liquidation. Okay. Now, the one big catch in all this is that if there are no books and records, or the books and records are in a condition that wouldn't enable them to be audited or financial statements to be put together, then the company is deemed to be insolvent from the time that those books and records haven't been kept properly. And in a lot of cases that we get involved with, the books and records are atrocious. You know, the stuff's missing. A lot of the times when we get the court type jobs, there are no books and records at all, which means that a director is then liable for all the debts that have been incurred by the company that haven't been paid for at the date of liquidation, excluding, of course, those that are currently covered by this moratorium period. There is some talk that if a company doesn't go into liquidation by the 31st of December, those protections might not be available to a director. Now, I haven't seen any case law on it. It was something that was mentioned, and it's been mentioned a few times. That might be the case. Then again, it might not be. But certainly insolvent trading is something that a director needs to be aware of. It's also another thing that a director needs to be aware of is director penalty notices. So they're issued by the tax office, and effectively what that means is that for any tax debt that remains unpaid, PAYG, superannuation, and now GST this year, the tax office can issue a director penalty notice, and in some circumstances that will make the director immediately liable for that particular tax debt. And there's a whole raft of different types of penalty notices that can be issued, some that make the director immediately liable and some that don't. But superannuation is a key one. And if you've got clients that have got those sort of problems, the key takeaway would be to act sooner rather than later. So I'm just checking. Just check the time. Okay, so we're pretty close to the end. And I'll just rush through this. I've done the preferences, avoidable transactions and insolvent trading. With insolvent trading, although a liquidator might issue a demand against a director for insolvent trading, ultimately the director might turn around and say, well, I don't believe that I was trading the company whilst it was insolvent, and may dispute the claim. Ultimately, just because the liquidator might issue a demand, if the director turns around and says, no, I don't agree with you, I'm not paying, then the liquidator's option is then to go to court and get a judgment against the director, or what we call a compensation order, effectively, for insolvent trading. It's happening more and more often. It didn't happen that often many years ago, but certainly insolvent trading there's a fair bit of case law on insolvent trading these days. If a director has means by which a liquidator thinks to pay for a compensation order, then it's more likely that step of going to court will probably happen. And there's a number of searches, obviously, that you can do to try and work out what someone's asset position is. Title searches, for example, directorship searches, maybe professional register searches. Sometimes you don't take that sort of action because it might be blatantly clear that the person doesn't have the ability to pay an insolvent trading compensation order. And the most common one would be where maybe the director's also gone bankrupt. So in that particular case, you might lodge as the liquidator a claim in the bankrupt estate and see if there's any dividend that might be paid out of the bankrupt estate. As I said, We lodge reports with the ASIC. They're confidential reports. They're not available to creditors and all the outside world, but they are available to ASIC. They get lodged. It's a form that we complete. It's many pages long. It details our investigations and things like that, but it's one of these forms that basically is a bit of a tick the box type form. It goes through what I think is an artificial intelligence program, because, as I said, we lodge them, and within a couple of minutes we generally know whether or not ASIC are going to want to invest in the affairs of the company. Now, if we report lots and lots of different offences, or lots and lots of debt, lots and lots of creditors, probably what would happen is we might not get that response. ASIC might have a closer look at it and basically determine whether or not that's something that they might want to investigate. ASIC can investigate the collapses of companies, and ASIC can take action against directors for various sorts of actions that or breaches of the Corporations Act. We report to creditors. I won't go through to that because I know that we're out of time, but one of the things we do is if we've got enough funds available, we just make a distribution to creditors. And so the distribution that we make to creditors is governed by the Corporations Act, but very simply, the way that it generally works is the liquidator's costs will come out first, and fees, and then payment to what we call priority creditors. And priority creditors are generally employees for their employee entitlements. So it might be wages, redundancy, annual leave, long service leave, any superannuation that they might be owed. That also goes to the super guarantee. So if a company hasn't paid its superannuation within a short period of time that it's allowed, it flips into super guarantee, and you've got to pay the tax office. So the tax office may lodge a claim in a liquidation for super guarantee. There's various orders of priority in relation to how those work. So wages and super are at the same level. Then comes annual leave, long service leave, redundancy and notice. So they all come. And then after that, unsecured creditors come next. The only other claim that might be made is by way of a secured creditor. And of course, so if a secured creditor's got an asset, it might be a fixed asset, for example, some plant and equipment that's been realised. After the realisation costs, the proceeds from the sale of that particular asset go to the secured creditor. And then once all that's done, we then ask the ASIC to deregister the company, and that's it. So happy to take any questions. And I'll stop sharing my screen at this stage. Okay, any questions from anyone? All right. Well, look, if there's no questions, you can see that it is quite a complex and detailed process that we've got to go through. But we're happy to, obviously, as always, if you've got clients that have got any sort of issues, whether it's maybe dealing with a liquidator because they might have received a preference claim, or they've got some financial difficulties, feel free to reach out to either Chris or I. We don't charge for any of that sort of advice, and we just try and make sure that we give you and your clients proper options that are actually available should they actually find themselves in some sort of difficulty. Please join us at any of our Red to Black seminar sessions. We welcome your attendance at those. They're short, sharp sessions that go for 30 minutes to 45 minutes. I think you'll find the content quite interesting. We've tried to make sure that it's something that you can get some value out of, and value that you might be able to then share with your clients. Chris, you want to add anything at this stage? You're muted, mate.
Just again, thanks very much. Other times people have asked, well, how do we go about appointing you or a liquidator? The simple answer with us is just pick up the phone and talk to us, or send an email. We're very happy to talk through situations, any situation. As I say, we don't, as Steve says, we don't charge, and it can happen very quickly and quite painlessly, really. So, yeah, yell out if there's any practical questions at any time. So, thanks a lot.
Yeah, absolutely. And just as a final point, we do work all around Australia. So, whilst we've got offices in Melbourne and Sydney, we do a lot of liquidations there elsewhere as well. So don't think geographically it's a problem. Thanks once again. Hopefully you'll have a really good afternoon. Okay.